Today, an Accra High Court revised the bail condition for the former Director General of the Signal Bureau, Adu-Boahene, setting it at 80 million Ghana cedis with two sureties. The bail conditions for his wife, the second accused in this matter, remain unchanged at also 80 million Ghana cedis with two sureties. The court also directed the couple to report 3 times a week for the next 3 weeks, and stated that they may only travel with express permission from the Economic and Organized Crime Office. Now, speaking briefly to reporters at the court complex, Adu-Boahene maintained his innocence. In the system, he has not been charged with any wrongdoing.
Any initial comment? Mr. Boy, any initial comment? What do you see about all the charges and the publicity?
Oh, I have not been charged of anything yet. None whatsoever.
So what do you say? You believe you come out from this as
Definitely.
an innocent man?
Definitely, yes.
Okay.
Right, so that was an exclusive with my colleague Latif Idris, who was in court today. Prof, I'm going to come back to you shortly to ask you if it is normal. This man has been in custody for over a week and he's yet to be charged. If this is normal, and what you make of the revised bail bond that is expected to meet before he can have his temporary freedom. Latif, what happened in court today?
Yeah, so
you can walk us through the argument for and against,
the
application to amend
for bail.
The bail.
That was so. When the case was first called by the court, the Deputy Attorney General, Justice Remsai, wasn't present, so he had to be stood down, and then he was recalled. When he was recalled, so he was stood down first because we were told in court that the Deputy Attorney General was filing processes at the registry. That's the affidavit in opposition of the application filed by lawyers for the suspect. Now, when he appeared in court, the affidavit in opposition wasn't on the docket of the judge. So the case had to be stood down again, and eventually was called the third time, by which time everything was set. And so there was the argument for, again and against. On his part, lawyers for the suspect, that is Atachia, he reiterated the point he's already made within the media space that the bail conditions put on the suspect are onerous and burdensome. And these are his words. They are burdensome, and he is unable to meet those bail conditions. So he prayed the court to amend same. The only challenge was that he had appeared in court.
The initial bail bond, I mean, the monetary,
aspect of the bill
was 260 million. Is that not it?
120 million for Adu-Boahene, and then 80 million for his wife.
Right.
Yeah. And so they felt that it was burdensome and onerous, and that they are unable to meet those demands, if you like. The arguments, there was this contention about whether or not Adu-Boahene has the capacity to satisfy or execute those bail conditions, because according to the Deputy Attorney General, the properties of Adu-Boahene that they have landed, it gives them the confidence that indeed the man is able to meet it, and so they shouldn't amend, the judge shouldn't amend the initial bail conditions put on him by Yoko. He also argued that the bail conditions should be maintained because the wife of the suspect, who is the second applicant in this case, attempted to destroy evidence when she was informed about the arrest of the husband. She has dual citizenship, and so the fear is that if they are granted bail or they are given a very conducive bail conditions and they're able to meet those, there is the likelihood that they will flee the country or the jurisdiction. And so the judge should not amend the bail conditions. But Atachia insisted that the bail conditions are burdensome and that there is a need for the court to amend same. The judge also had to come in because, if you recall, Atachia's point was that he wanted bail for the client, not amendment of the bail conditions, wanted bail. But then when they got to court, everything changed. And so they had to clear that first. And then Atachia considered that, yes, indeed, he had come before the court for the trial judge to amend the bail conditions and not that he's seeking bail for his client.
Right.
And so the argument had to change at that point in time.
And so the judge came to a decision.
She came to a decision that, having listened to both sides, she granted what Atachia wanted. So she watered it down from 120 million Ghana cedis to 80 million Ghana cedis for Kwabena Adu-Boahene.
Right.
This time again with two sureties, one to be justified. For the wife, her bail condition remained at 80 million Ghana cedis. The only variation now is the two sureties. None of them will be justified.
So both husband and wife are still in the custody of Iyoko.
So Atachia wanted them to remain at the court, or in the courtroom, if you like, for the processes to be rolled out and for them to execute the bail condition. But Iyoko officials deemed it fit, so they took them back to the custody of Iyoko. So as we speak, the expectation is that the process is ongoing and that his lawyers and the AG are working around the clock to make sure that he meet, because according to Atachia, who is lawyer for the suspect, he does not expect the two to spend another night in the custody of Iyoko. He is confident that at the end of the day today, the two of them will go back to their four children. He made a case in court that it's been 8 days straight, and the four little girls have not seen their parents, and it's causing some trauma. And so he prayed, it was part of his prayers to the judge, that the children need to meet their parents. It's been 8 days, they don't know their whereabouts, and so he wants them to be freed, at least momentarily, to go and make time, some quality time with their children.
Let's listen to Samuel Atachia, who is lawyer for Kwabena Adu-Boahene and the wife.
It's telling you that justice is with the court, not the people who have incarcerated you. Because you will know that if your liberty is at the sufferance of those who have captured you, you can never go home. But now, the custody of your peace is with the court. And this is what we call the court bail on reasonable terms. If you see that the woman's own was without justification. So we are going to go and ensure that whatever is necessary will be done before the registrar, not them. But they are saying that because of their safety, they want to take them to the place. And when the order is ready, they can come back and then they satisfy the conditions before the registrar and not Iyoko. And today they can have their freedom. It is over executed because what they have with them is more than what the judge has ordered. Unless there's bad faith, I don't see why they shouldn't go home today.
So Samuel Atachia is lawyer for Kwabena Adu-Boahene, the man at the center of what the AG described as a crime of monumental value. The reason why he's in court today. Let me bring in again Professor Kwabena Piagetua. Prof, so you've heard what happened in court today. I'm curious to know, Mr. Kwabena Adu-Boahene says that close to 10 days he's yet to be charged. He says he's not been charged with anything whatsoever. Is it normal that after 10 days, the state is yet to charge this man, the accused of stealing so much?
Sometimes it goes beyond that. It depends on the complexity of the case and the ability to access evidence and so on. So that explains why for 10 days he has not been charged.
And then the bail condition was revised today from 120 million Ghana cedis to 80 million, and then to report 3 times in a week to Iyoko, and then further, if he wants to travel, Iyoko must give him the permission. You will say that it is reasonable?
Well, I will say so. I don't know all the facts. Every bail condition is determined on a case-by-case basis. So the Attorney General is best placed to have requested for the $120 million cedis as the bond that should be determined before the person will be granted the bail. The court in its wisdom has concluded that it should be reduced. I wasn't in court, so I don't know the details of it. But I think that at the end of the day, a bail is simply some pre-trial restrictions which are placed on a person who is a suspect in a case or an accused person, so that it will not jeopardize or place stumbling blocks in the trial of that particular case.
Finally, before please go on.
So if that is what the decision the court came to, then I think they feel that that is necessary, and also the 3 times a week report and so on. I think it's basically to ensure that the person would not abscond. So they may have the facts and may know why they think that he may run away, or whichever reason they may have for deciding to impose that amount. But it's also determined by the amount of money that is in dispute, or the amount of money on the basis of which he's been arrested and being prepared for trial, because the amount is huge. And so there has to be some amount of money that may be may commensurate with the amount that is in dispute, so that they'll be able to ensure that even if the person would find a way to run away, there will be a way to find some money from his side that will compensate for his decision to run away and not face justice.
My final question. Yesterday, you heard the Learned Attorney General justify the arrest of Mr. Kwabena Adu-Boahene, and the subsequent commentary that came up, some condemning him for what they described as him turning himself into an investigator and a judge, virtually declaring the man guilty even before the man was taken to court. What is your take on it? Was the AG right in running the man down the way he did before the public eye?
I'm slow to come to that conclusion. I'm of the view that, in a case, we have 2 sides. There are 2 parties. One, in this case, the prosecutor feeling strongly that he has the evidence to successfully prosecute this guy and have him convicted. The other side is to say that he's not guilty as charged, and therefore I will make sure that he gets exonerated. So the Attorney General is presenting his side of the case. That's why he's saying that he will be jailed and so on, because that is why they are going to court. He is going to court in the first place. And so I think that is normal for a prosecutor to do. I'm also thinking that in this case, the Attorney General is trying to be as transparent as possible. Even if he might have gone a bit too far, I think it can be excused, because he wants to make sure that there's some sort of transparency in what the Attorney General's office does. And so if, on the other hand, there was no information coming at all, he may have also faced criticism for not letting the world know about what is going on with this person who has been arrested. And so in this case, it's important that some information should come out, because it's a case of public interest. It's the state money that is alleged to have been stolen. So the people should have an interest in the case.
Well, let's leave it here for now. Thank you so much for your time this afternoon. Professor Kojo Appiah-Gyatuam is with the University of Ghana. We've got some